Good morning.
Good morning.
Good morning.
Morning.
Good morning.
Morning.
All right. We are here for the 11 o'clock oral argument via Zoom for the 5th District Court of Appeal. At 11 here, we have case number 2185, the Kidwell Group versus First Liberty. I am Judge Eisnagel. I'm joined today by Judge Vander and Judge Harris on the panel. Please keep in mind that we are streaming live and this oral argument session is also, of course, being recorded. With that, counsel for the appellants, how much time would you like in rebuttal?
5 minutes, Your Honor.
Okay, you certainly need to watch the clock, but I'll attempt to remind you when we get there.
Yes, sir.
And with that, counsel for the appellant, you're free to proceed whenever you're ready.
Thank you, Your Honor. May it please the court, counsel. Good morning, everybody. I want to frame the issues a little bit and then obviously open to any questions. There was the motion for summary judgment was filed. The order was entered. The order was not based on any of the grounds raised in the motion. Then the appeal came, and it appears that in the appeal, they're sort of stepping away from the order also. In the case itself, there's no question there was direct physical loss to the insured structure, residence premises, dwelling, other structures. And so the coverage was triggered. The homeowner retains an engineer to determine how to do repairs. Those repairs could either be permanent or could be intended to protect the property from further damage as is required under the policy. And that engineer, yes, sir.
Right?
I'm sorry?
It has to be solely to protect the property under the policy to trigger that.
Under the reasonable repairs to protect the property for that $3,000 coverage, it does. But to come up with the repair protocol, an engineer obviously is going to have to determine the cause of the loss in order to determine the appropriate repair. It can't be done any other way. And he can't rely, it's signed and sealed by the engineer. And so he can't simply say, well, the insurance company has said this is the cause. And so I have to go with that and create a repair protocol based on the insurance company's causation. He has to make his own independent. Yes, sir.
Is the only issue before us here the additional coverages, reasonable emergency measures provision? Is that I wasn't entirely clear based on the initial brief if you're making two separate arguments or if that is the dispositive issue.
It would, well, it's difficult, and it's under both repair or reasonable repairs. The problem is we had to address the order that was entered. And the order says you can only recover this through appraisal or bad faith. Well, if you can recover these through appraisal, you can certainly recover them from a jury. An appraisal panel is simply a different fact finder than the jury.
I guess my question, and just to make sure that we're not missing each other, I guess my question is, are you seeking to recover, is your client seeking to recover under the only under the additional coverages provision, which entails reasonable emergency measures, which you referenced just a moment ago? Or are you also arguing that you can recover under some other provision?
There are two provisions. The repair provision for the repairs to the insured structure, and it is also covered under the additional coverage. It's covered under both. Go ahead. Yes, I'm sorry. Go ahead.
I guess the question I have there is, I mean, can it be under both? Given the language in the reasonable emergency measures provision that requires that the measures are solely to protect, is it even possible for it to be both?
It is, because the reasonable repairs can be permanent or not. So if they're a permanent repair, they're going to fit under either one of those coverages. And it specifically says it may include permanent repairs. So those permanent repairs would fall under just the coverage A, coverage for repair or replace damaged property.
So under your view of the policy, you know, you could have two different kinds of emergency repairs. One would be sort of just the Band-Aid, if
Yes,
you
sir.
will. And the other one would be, well, gee, we need to go ahead and make a permanent repair because on sort of an emergency basis, because if we don't, there's going to be additional damage. Is that your reading of it?
Sort of. I think what it's saying is you can do a repair, and that repair may be a permanent repair. There may be only one repair option, and that repair option prevents it from further damage, but it also is the permanent repair. There may be only one repair technique that accomplishes both, and so it's going to be covered under both those things. Frankly, that issue wasn't litigated below. There's no record formulated on that particular question. The question that the trial court addressed simply said it can go to, or it must go to appraisal. Obviously, the appraisal clause has been removed from the policy, but implicitly saying, well, it's covered, but the fact finder in this circumstance has got to be an appraisal panel. Well, it's a fact issue. All these questions are going to be fact issues and can be fleshed out with a jury. I mean, their
Mr.
position is,
Mason,
yes, sir.
let me ask you this, kind of an odd procedural setting here, because in a way, you know, your opposing counsel, maybe he should be arguing first, because I think we're really talking tipsy coachman here. I don't, you know, they've conceded in their answer brief that the appraisal provision, you know, the bad faith were not valid basis to grant the summary judgment. And as far as the summary judgment basis, I really don't know how the trial judge could have found that it was clear what the plaintiff's intent was in getting a report. So I think we're totally in the tipsy coachman realm. In deciding tipsy coachman, do we need to know, is it helpful for us to know, or is it important for us to know whether or not the pool and the dock were covered under the policy, or are they not covered, or is that an unresolved issue?
It is unresolved at this point. I can tell you, handling thousands of exclusion cases, that if an exclusion is the thing that's being litigated, then the trial counsel will sit with the engineer or the contractor, go through it painstakingly to determine the precise cause of loss, each element of the loss, to see if any of them fall within or outside of an exclusion. Then affidavits are in support, or depositions in support or against that are put into the record. And then we go have a motion for summary judgment on the application of the exclusion. And there is a lot of litigation that goes into that precise issue. None of that has happened. None of those factual findings have been developed in this case. But I know, sitting in the chair of the trial counsel, you've got to go through that analysis with your expert to see, all right, does the exclusion apply to some? Does it apply to none? Or does it apply to all of the elements of your damages? And you look at each element of damage and see if it falls into or outside of the exclusion. The court then determines the application of the exclusion, and the jury determines the facts and whether or not they fall within that exclusion. And so we can't go into the tipsy coachman at this point, because none of those facts were developed. And we'd be hamstringed to try to argue about it here today. And your point is well taken. As I sat here preparing, I thought I would almost tongue-in-cheek say I'll reserve 25 or 15 minutes. But because I thought it really, I don't know what their argument's going to be other than tipsy coachman. And I don't think we get there. And a practical matter, this trial court order is being waved around in other trial courts now, and to tell judges, hey, this can only be determined by appraisal or bad faith, in spite of the fact that obviously they've even waived those arguments or backed off of them. If there are no more questions, though, I don't have anything else.
All right.
Thank you.
Counsel, you'll have, I think it looked like you had 11 minutes left for rebuttal. So we'll see what you want to do when we get there. Counsel for the appellee, you're recognized.
Thank you, Your Honor. Scott Samus for the appellee, First Liberty. May it please the court. The question before the court, and Your Honor is correct, this is a tipsy coachman situation. So the question under the school board versus radio station WQBA case is, if you look at the record on appeal and the result as a matter of law is correct, the court should affirm. Even it stands to reason the appellee can present any argument supported by the record, even if not exerted in the trial court. In the trial court, we did make the arguments that I'm going to make here today, which is there are two things in this record that are immutable and dictate the result that we had here today, and that is the report and the policy. What does the policy say? And I will confess, I thought today we would be arguing only about the reasonable emergency measures language from the reply brief, but I'm happy to talk about both, because what this report does furthers neither of those coverages under this policy. The reasonable emergency measures have to be necessary measures solely to protect covered property from further damage, or under the main policy, it must repair or replace damaged property. This report, they issued a report that does neither. It doesn't protect anything. It doesn't repair anything. The appellant wants First Liberty to deplete $3,000 of its reasonable emergency measures coverage and hand the Schonenbergs a report that does not move them 1 millimeter closer to having their property protected or repaired. What they have issued is a typical expert report that is used when there's a dispute over scope of repair, method of repair. They went out, they examined the property, they talked about the weather conditions, they issued a cause of loss opinion that matches the cause of loss opinion. It was hurricane on the dock and hydrostatic pressure, which as an aside is not covered, but that doesn't even matter that it's not covered, because this type of report is the kind of thing that is awarded as a cost in litigation. I think the best way to think about it is this. Probably the most common type of reasonable emergency method measures case in Florida is water dry out. You have a hurricane, you have a broken pipe, floods the kitchen, and the first people who show up are the dry out people. And they put down fans and they do dehumidifiers and they mop up the water and they suck it up. And sometimes they have to use more complicated equipment or more equipment. And the dispute that usually arises out of that is, did they overcharge? You know, did you really need 10 fans? Did you really need 7 people out there doing the work? And when that gets litigated or that gets appraised, both sides hire an expert who does just what Kidwell did in this case. They generate a report that says, yes, this is causation if that's in dispute. And they say, this was the proper way to remediate the property. This is the proper way to protect the property. This was the proper way. And that's why the damages are this much as opposed to this much.
Let me ask
This,
you.
sure.
Let me ask you this. Let's assume that the pool is covered. And let's assume the report said something along the lines, this is the repair that's recommended. If this repair is not effectuated within 90 days of the damage, there'll be major consequences and the cost of repair will be 10 times what it would be if this other simpler repair was done within 90 days. Would that qualify then?
No, Your Honor, because it is purely an opinion. That is talking about the scope of the repair. That would be evidence at a trial when there is an argument over this needed to be done, this didn't need to be done. And I'll give you, and this is how the illustration fits.
Doesn't that type of report, I mean, a lot of things people don't start to work on until there's an engineering report or something like that.
Right.
So you bring in a pool contractor and he follows what's in the report as far as guidance on the repairs to do so, sometimes, you know,
Right.
like in my hypothetical, it's one type of repair, one major repair if one thing, and a minor repair if different. So the pool contractor would use that report to follow those instructions. So isn't that sometimes a part of the repair is deciding what needs to be repaired and how it should be repaired?
Here's the distinction, Your Honor, because I think there are a lot of illustrations of that. When you talk about, I think sinkhole's a good example, where you have an engineer that comes in and talks about method of repair and participates in that repair. So when the engineer is giving a plan that then leads to a permit being issued and is a part of a step in an act, a measure, a necessary measure to move it toward remediation, then that is something that's recoverable under the policy. So a monitoring engineer in a sinkhole case, a general contractor who is coordinating and overseeing the job. When there is participation in activity that moves it forward, that's one thing. That is repair, replacement, protection.
I mean,
measures.
you see the fine. It seems like there is potentially sort of a fine line here in your argument, right, counsel? I mean, so what if the same report had been issued, but, you know, part and parcel with that was a contractor, a pool contractor, who then maybe the pool contractor hired the engineer and received the same report. Why is that different? And maybe it is, but why?
It is because there's a participation in something that's actually being done. And I think the test is the insured, for the money that got taken away from their insurance limits, moved toward the goal, which is repair or protection. When you look at the roles of this as it goes through litigation, you have the people that do something and accomplish something and participate in that process. And then you have what AQA did, which is opine about whether it was right or it wasn't right. And in fact, I think
What about in this case?
telling.
What if the contractor didn't hire the engineer, but the engineer came out, did this work, and then the next day the report was sent to a pool contractor who then pulled permits and came out to the site to start work?
If there were evidence in the record that said that the engineering report was a necessary step to get that permit and accomplish something in the string of something happening, some kind of act which is a measure toward the goal, that is repair, replacement, or protection. And I think the best example is there's not a single case. These kinds of fees for this kind of report are classic costs of an expert opinion. What they do is they don't repair or replace or protect. They render an opinion, and the opinion was generated.
Is that as a matter of law or is that factual?
No, that's as a matter of law. That's what this record, and this brings back to Your Honor's point about tipsy coachman. What do we have in front of us? We have the report and the policy language. We don't have any kind of an affidavit saying, you know, this report was used by this contractor or was filed with the county to get a permit. There's no action. It is an opinion standing alone, just like the opinion of an expert that would come into a trial.
Do we know for sure that there wasn't a corresponding contractor seeking to use the report?
There's nothing in the record about that, Your Honor. There's no affidavit from the plaintiff saying,
Right.
you know, this was a necessary step.
But whose problem is that though on appeal? I mean,
Well,
who, right?
Well,
If there's lack of evidence,
right. I mean, we point to the report that says, what did the report do? We went out and looked, and we did a recommendation on method of repair and causation. That's exactly the testimony you would get from an expert witness at a trial, that if you win the trial, you get costs for. That there is, and it's telling, nationwide, there is not a single case that finds this kind of coverage for a standalone. They are asking to pay for a report, a piece of paper that gets handed to the Schonenbergs that does not advance the repair, replacement, or protection of this property whatsoever. And this is a classic example of something that would be a cost. If you look, and the closest analogy is really the Kings Hill case, where a public adjuster goes out and says, I disagree with the insurance company on causation, on damages, what needs to be done. The public adjuster says the whole roof needs to be repaired. The insurance company's expert says only 4 tiles blew off in the storm. That expert's report and opinion is not part of the covered loss. It's a cost for an expert consultation. It is a standalone opinion.
And maybe I'm turned around, and that's why I'm sort of asking the question so that you can set me straight. But, and this is a summary judgment case, right? And
correct.
So who had the burden at summary judgment to present evidence demonstrating entitlement?
We did, Your Honor. We were there were cross motions for summary judgment.
But as it turned out, right?
We won. So
you had the burden to present summary judgment evidence, correct? The initial burden, right? So if there's evidence missing, did you need to present evidence at summary judgment that this report was not being used by a contractor to make repairs?
No, because I think that the record on its face shows exactly what the purpose of it was, and it was just an opinion. And if there was something that was done to incorporate that in a fix, I think that was up to the plaintiff to come forward and say, no, it's something other than what it says it is. We are pointing to what it is, what it professes to be itself. They are asking, the bill that came with it is not for coordination, not for overseeing, not for pulling a permit. The bill was for creating a report, writing a piece of paper that accomplished zero, except for to be something that can be argued later on for scope of repair that someone else is going to do. And, this actually, Your Honor, I'm sorry.
I understand. In this case, maybe that turns out to be true, maybe not. But let's say, a hurricane destroys the house and an engineer comes in and designs the plans for the reconstruction of the house, but doesn't take any supervisory role. Contractor uses those plans and builds a new house. Are you saying the engineering plans for that were meaningless?
If there's a participation in the engineer, and the engineer then, those plans are used to get permits and it becomes a component and the engineer is a participant in those activities, I think that crosses the line.
But that's my question, and I may be missing something, and that's why I'm asking it, is how, given the summary judgment standard, how do we know that didn't happen?
Because the language of the report itself says what it is, and the bill that they sent to First Liberty says for preparation of a report and nothing more.
But why would the engineer have to say in the report, oh, and by the way, this is going to be used by some contractor I've never met?
Because that's what makes it a covered claim. I mean, if there's evidence that there's a participatory
I thought you
action,
said what makes it a covered claim is if it's being used to make repairs.
No, if the engineer creates something that gets a permit and becomes a component of a repair, then that's a different story. This is a charge for writing a report and handing it to the Schonenbergs.
But I feel like we must be missing each other, because I guess what I'm saying is, how do you know it? While the engineer might have just viewed it as a report, how do you know it in the bigger picture? How do you know it wasn't a component of a planned repair?
Because presumably, if it were, there would have been a counter affidavit or an affidavit in support of that fact.
So I guess the question becomes, who at summary judgment, was that part of your initial burden, or was it part of the party opposing summary judgment's burden once it shifted to them. Is that the question?
I think that the facts, yeah, well, I believe that we met our burden by presenting to the court the report, the bill that says what the report is for, and the policy, and that's sufficient, and that's why tipsy coaching applies.
And then if your position is, look, if this report, which sort of on its face appears to just be this isolated opinion, and I mean, look, when you read it, there's some merit to what you're saying. I mean, sort of, you're saying that, look, once we presented this report that on its face appears to just be an opinion, a sort of an isolated opinion, then it was the non-movements became the non-movements burden to present some evidence that no, it was part of a bigger plan.
Or that the plaintiff participated in something. Something was accomplished as a result of it.
No, but my specific point is that was your position, is that was their burden to then come forward with something to say something like that, right?
Yes.
Okay.
Yes. Your Honor was talking about and one of the points that was made in the reply brief is this idea of additional coverages. And I think that really, when you think about the additional coverages beyond repair and replacement that are in there, it really reinforces First Liberty's point. And mold is a good example. Okay. The mold is an additional coverage. The mold endorsement specifically provides for testing, investigation, and evaluation. So when the policy is giving money for creating reports, for creating what AQA did in this case, it says so. And it has to say so in an additional coverage because otherwise it is not covered. So this really, and then the fact that there are no cases out there where this kind of report, I mean, nothing even close, has been covered, I think it's to a larger point. Homeowners insurance is supposed to protect the property and restore the property. That's what the plain language of the policy does. And, the Denny Associates case says that insurance policies are not supposed to be construed to reach an absurd result. And if this now becomes covered, then, people can come in and create these, essentially just these reports that do nothing, bleed $3,000 out of, the reasonable emergency measures coverage, and the insured is that much coverage is gone and nothing has moved 1 millimeter forward. I would submit, or my client would submit, that is contrary to the plain reading of the policy as a whole and really is an absurd result. And this is the kind of thing, the kind of expansion, unwarranted expansion of coverage that makes insurance unaffordable. So we would ask that the court affirm.
Well, let me ask you this. I'm looking at the reasonable repair language. Let's assume we could divide this report into two parts. And let's assume $2,500 of work was to say what the cause was. And $500 was to say how to fix it. And it was in subsequently, a pool contractor came in, followed those directions, and fixed the pool. In that scenario, could a fact finder determine I'm not going to award $3,000, but I'm going to award $500 because that's the part that was a reasonable cost to repair the pool and it was necessary to prevent further damage?
Well, it's supposed to be solely, first of all, and I think that there would have to be some measurable advancement caused by the report, something beyond.
What if he split it into two reports and said, here's what caused it. That's one report, $2,500 bill. And then there's a second report and said, this is how you fix it, $500. And a pool contractor came in, followed that second report and fixed it.
Writing
the problem on solely?
The money for writing the report is not covered because it doesn't do anything. If the engineer participates in the repair, then that may be a different story if it's reasonable.
Isn't the engineer participating in the repair by saying how to do it?
Not at all. I mean, you could get 20 opinions. That's like getting, public adjusters.
If the pool contractor followed that report that said how to do it, pool contractor says, I'm not in the business of deciding how to do plans. I can implement them, but I don't make those determinations.
Right. I mean, what Judge Evander's asking isn't, I mean, we don't ask contractors to be engineers.
Right.
Right. So, why isn't this a situation where the contractor would come in and say, yeah, you have a major problem, but I'm not sure how to fix it. I need an engineer to tell me what to do, and then I can do it. So in that circumstance, why isn't the report, why doesn't it fall under the policy?
Because those facts aren't in the record. What we have here is a bill for writing a report and nothing else.
Okay. All right. Thank you, counsel.
Thank you, Your Honor.
And with that, counsel for appellant, 11 minutes and 7 seconds. You can proceed.
Yes, sir.
Well, counsel,
Everything.
was it,
Yes.
I mean, who, I think I think opposing counsel sort of raises a reasonable point. And I think maybe we've identified one potential dispositive issue here. And that is who had the summary judgment burden to demonstrate. And I understand you might disagree with counsel's analysis, but let's say for a moment, let's just talk about the summary judgment burden. If as part of this report, it needed to be part of an actual plan to do something. Okay. Why isn't it enough at summary judgment for opposing counsel to put on evidence that, hey, look, here's the report. It appears on its face to be independent of any actual repair or any actual action, therefore not covered. Why isn't it your then obligation as the party opposing summary judgment to submit an affidavit? No, sir, because we used this report with contractor ABC to repair the pool, and this report was used by the contractor.
Well, factually, we wouldn't be able to do that here because as soon as the bill got sent in, they breached the contract at that point immediately, and it's breached. But the report itself and the assignment of benefits do establish that it is a report that contains a protocol for the protection of the property or repair of the property. It says,
yeah, counsel, that's not, I mean, a protocol, doesn't really help much if you're not actually going to do it, right? If you're not going to do the repairs, right?
We don't know. I don't know the facts. I mean, I didn't handle it at trial level, but I don't know the facts. I do know there's a repair protocol in here. The bill got sent in and it was immediately denied, and that's when the breach occurred. And at that point, I don't know factually where they were in the repair process. And the assignment itself says it is.
I guess the question is whose obligation was it to put on evidence at summary judgment?
It was
to
theirs.
The actual.
Yeah, it was theirs to show that there is no genuine issue of material fact at all. And they didn't do it. The report itself creates that material fact, but the circumstances do also. I mean, it was breached before potentially any repairs could have been done. We've got the repair protocol, the bill gets sent in, and you have to think of the implications of what they're asking. We've got engineers involved. You got a fire case, immediately hire an engineer, comes up, this is how you fix it, bill gets submitted, that goes out to bid. You can't even bid it for the general contractors of the subs. You can't even bid it without architectural drawings and the engineering reports. You can't tell your client.
I'm not sure why the alleged breach of contract by the insurance company ends the story. I mean, it seems to me that if we're going to view this as requiring that the report be in some way used as part of an emergency repair, and they've said the report served no purpose, why shouldn't we put the burden on you to say, yes, it did serve a purpose. It was incorporated into a repair.
And what happens?
Don't we look at it down the road at the time of the summary judgment, not the day they say breach, and then when we stop looking at events at that time? Why wouldn't we look at the events to see if the report was ever utilized in some way to effectuate a repair, particularly given on the emergency provision when we're talking about whether there's an emergency to preserve property?
Yep. On its face, it says it. And I think those are valid issues at trial for them to bring up and say that. But at this point, when the summary judgment occurs, the grounds that they filed summary judgment on are only three. One is that there was no direct physical loss. Well, we know we're past that. And then they say it does not constitute a reasonable emergency measure. On its face, a factual issue. We have a repair protocol in it. They say they have ignored the repair protocol, saying it doesn't matter. It's part of the report.
Counsel, what if they, what if in interrogatories or a deposition, I understand maybe that's not realistic in some cases, but in interrogatories or a deposition, your client says, yeah, I thought maybe I would use this at some point to, for a contractor to repair the pool, but I didn't have any specific plan. I hadn't contacted any contractors, and no contractor had told me that they needed this engineering report to do so. What, and they submit that as part of their summary judgment evidence. Do you lose?
Likely, I would think so. Yeah.
So, at the end of the
If they
day,
had no intent and it's in the record and it's established as a matter of indisputable fact, it'd be a very difficult.
You concede that they can't just get a report in, sort of out of the blue for no reason. It needs to be a part of an effort to actually do emergency repairs, right?
It would have to be intended to do either repairs or emergency repairs. And on its face, the AOB says exactly that the purpose is to preserve and protect my property. This is signed by the insured, my property from further damage. Says it right there. They cannot get over that. It creates a fact issue right there.
I don't know. What if the report said that, but then in deposition, your client said, I thought maybe we would use it, but I never talked to any, I didn't hire any contractors. I never talked to them. I don't know if they would have needed it. Doesn't that at that point, there would be no issue then, right? Of fact.
I think under the old standard summary judgment, which this was, that still creates a fact issue. Under the new standard, likely not. Likely not. But I don't want to lose sight of what the actual rulings were, and these issues should be litigated and maybe teed up again and ruled on specifically. And here we just don't have the factual findings. For tipsy coachman to apply, the factual findings must be in the record. And what we're talking about is they're not. And if the factual findings are not in the record, we can't just assume one way or the other that they would have been determined. It goes back. Let's litigate that issue instead of basing it on a tipsy coachman, which requires that those facts be established in the record. They've got to show under that doctrine that the facts are established. And what we've been talking about here for almost 40 minutes is they're not. And again, this order is being waved around. It just needs to go back and we can litigate these issues. We're not saying this has to be paid. We're saying it's a fact issue. The jury's going to have to determine it. Thank you. Unless you have any other questions.
Counsel, does the panel have any additional questions?
Thank you
Okay.
both.
All right. Yes. Great job on both sides. Thank you very much, counsel. And with that,